Good morning, gentlemen. Can you hear us?
I can.
Terrific. Welcome.
Good morning.
All right, we'll get things started. Welcome to the May meeting of the Commission on Governmental Ethics and Election Practices. We'll start right with agenda item 1. It's ratification of the minutes of the April 30th, 2025 meeting. Does anybody want to make a motion?
I move they be accepted as written.
Commissioner LeClaire moved they be accepted. Is there a second?
Second.
Terrific. It's been moved and seconded that the minutes of the April 30th, 2025 meeting are ratified. We'll do a roll call since we've got people all over the place. Commissioner Hastings?
Yes.
Commissioner Marble?
Yes.
Commissioner LeClaire?
Yes.
And I'll vote yes as well. Our second item, agenda item 2, is a request for investigation for the school construction referendum in Cape Elizabeth. And I think we've got some parties here. We've got complainants. Would the complainants raise your hands? Okay, terrific. And the respondents? Terrific. So what we're going to do is I will have Mr. Wayne give us a brief background on the complaint and the responses. We will ask any questions we have of him. Then we'll ask the complainants to come up to the witness table and you can address us, and we'll give the similar opportunity to the respondents. Mr. Wayne.
Thanks. This relates to 2 referenda that are on the town ballot in Cape Elizabeth regarding whether to borrow money for school construction. And one of the referenda was on the ballot last November. It was November 5th, 2024. And then one of them is coming up on June 10th in a couple of weeks. The complaint was filed by Larry Benoit and Mary Ann Lynch. They believe that the superintendent and the school department has made more than $5,000 in expenditures to influence both referenda. And they are asking the commission to do an investigation and to consider whether or not the superintendent or the school department was required to register with our office as a ballot question committee and file campaign finance reports disclosing the expenditures that they made to influence the referenda. The response that we got from the superintendent is that he viewed these advertisements as something he was supposed to do in his role, that there was a mandate given to an advisory committee to engage with the public, encourage them to provide input at different kinds of public hearings, public meetings, with public officials. And so also to educate the public regarding what the limitations of the current schools were, and to educate them on how the proposed school construction would resolve those or address those limitations. So he viewed this as part of his public information mandate. And he shared with us in an interview we did with them that, and I forget his exact wording, but it was something to the effect of, I didn't recognize that this might entail campaign finance reporting, or I didn't have an idea that it would. And however he phrased it, I summarized it. But the phrasing in the complaint is my own summary of his remarks. We received email correspondence yesterday around noon from Mr. Benoit and Ms. Lynch. They'd like the commission to consider that an awful lot of information was released last Thursday. This included the response from the superintendent and also a staff memo from me. And they would like to make a pitch that they should be given an opportunity to provide additional written information. So they had asked that this matter be continued until a meeting in June. The decision was made by the chair to move forward with this meeting, but they'd like to continue to, they think that the process would benefit from more written information from them, and they'd like an opportunity to provide that in the future.
We can address that when you address us.
One little factual point, I just want to be clear that the content of the ads,
So let me go back just
Yeah.
a second on the continuance.
Yeah.
You contacted the respondents, correct?
yes, and the superintendent conveyed to me that his preference was that the events occur this morning, like they were scheduled, but he was willing to, the school department would be willing to defer to the commission and accommodate whatever the commission wanted to do.
But he couldn't make our meeting date next month.
I believe he said that he had a family travel conflict that would interfere with the last week of June. Typically the commission meets in the last Wednesday of June, and I thought I heard from him that might pose a problem for him.
Okay, then.
Yeah. The one factual point that I wanted to mention is that the content of the ads consisted of community outreach materials that were prepared by the architects. The town, on the recommendation of the advisory committee, had hired Harriman Associates or Bill Harriman as the architects for the project, and one item in the contract was for them to prepare community outreach materials, describing the issues and the solutions and so forth. And those have been used in a variety of ways, including in the advertisements in the Cape Courier newspaper, but also in posters and other materials as well. The superintendent informed me that there's not really a precise line item that the school department is charged for these community outreach materials. So staff offered a very preliminary estimate that maybe each material cost around $300. They could have a greater value. That was really just sort of a preliminary estimate on my part.
It was a bit unclear in the materials what the involvement of Harriman was. As I understand it, they prepared the ads that appeared in the Courier. Is that true? Or is that your understanding?
Yeah, I mean, I think they prepared those graphics.
Yeah.
The language, the graphics, the design. I think those designs were intended to be multi-purpose. That they weren't just going to be ads in the newspaper. I think they were used for multiple purposes. But yes, that was what Harriman produced in collaboration with the school building advisory committee, and then later on with the superintendent.
Okay.
Yeah.
I didn't mean to interrupt.
No,
Go ahead.
yeah.
What was the total amount spent for newspaper advertising?
Well, each ad in the Cape Courier cost somewhere around 900. I'm rounding a little bit, depending on the time period. The earlier ads, I think, cost around a little less than $950. That was the pure advertising cost paid to Cape Courier.
Yeah.
And then the later ads cost $1,015.20. And that does not include, if you were to throw in some of the design costs from Harriman, I think that's an expenditure that's potentially reportable, that the numbers I just gave you don't include any costs paid to Harriman.
What was the total, just the newspaper advertising?
I'm gonna throw out a number and maybe the parties would like. I mean, I think there's a disagreement about whether these were intended to influence the election at all. So there could be a disagreement about how many you want to count. But
And there's an issue, I think, about whether this is two events, two ballot initiatives, or it's to be considered altogether as well.
correct. In a May 1st email that Larry Benoit sent me, his point was, this is a continuous campaign that in November 2024, a school proposal was narrowly defeated by the voters, and then right away, the school board decided to move forward with a school construction plan that would be a little bit reduced, and that this ought to be viewed as one continuous campaign, and that the $5,000 threshold was exceeded. If you look at the advertisements for the two referendums together, the staff point of view on that is based on the way the statute reads and our previous advice, we would recommend that they be considered separate elections with separate $5,000 spending thresholds. But that's something for you to decide.
And you were gonna throw out some numbers,
Well, yeah, I mean, I counted for the 2024 election. I believe the complaint included 5 advertisements that the complainants viewed as influencing the election. And so they'll correct me if they have a different view, but I think their view of the ads were those total 5,000 or a little bit more, and then they think the design costs ought to be included as expenditures to influence the election. And the superintendent made me aware of a 6th advertisement from 2024. So I took the liberty of throwing that in, even though the complainants didn't list that one, because I wanted the information to be as complete as possible. So the total cost to the Cape Courier for those 6 ads was somewhere in the range of a little less than, somewhere around $6,000 or a little less. And then by my count, for the 2025 election, there were 5 ads in the Cape Courier newspaper that the complainants would likely consider. The cost to those would be about $5,080 if you were to consider all 5 of them as influencing the election. The superintendent would say to you, that wasn't the intention of the school department. They were intending those as public outreach materials.
Sure, please go on.
Just a few more notes. At the time I wrote the staff memo, I just received some written materials from the superintendent, and I conducted an interview with the superintendent. I put together a memo very quickly. I didn't have an opportunity to talk with John Bolton about the various legal issues, one of which is sort of the commission's authority to regulate public entities. And, is a municipality a person that the legislature intended to potentially have to file as a ballot question with us? That's something that I've discussed a little bit in the memo, but I didn't have a chance to talk over with John. And we can provide you, if you want to continue the matter beyond today, we're happy to provide you with whatever information or analysis about that.
Maybe John could discuss that a little bit right now.
Sure. So, I mean, there is a sort of a foundation or a basic question that I think is sort of a threshold question in this matter, which is, the campaign finance laws and the ballot question committee definition talks about persons. There's a definition of person. It doesn't specifically say municipality is a person. It has a list of other general broad types of entities instead, which, there's I think a fairly difficult legal question about whether a municipality falls within one of those entities. And I think the history of this, which I found fascinating, was that, this has come up twice before, and the commissioners were split in both cases on whether or not, the government entity was a person. So one thing I will say about this is that in the bear baiting case, that involved expenditures by, or alleged expenditure, I guess, potential expenditures by a state agency. And the case law on this, there is there's a distinction that's drawn between municipalities and state agents, arms of the state. So, and I would say when you're talking about a state agency, when a statute uses the term person, there is a fairly strong presumption that the legislature does not intend state agencies to be considered persons. And generally the courts will require that there be explicit language in the statute that says, defines person to include it as an arm of the state government. It's murkier, right, with municipalities, which are sometimes called municipal corporations, right, which are arguably corporate entities. And there are some broad terms in our definition of person that could arguably encompass, I think organization is also used as an example of a person, which could include a municipality. There is very old case law from the law court from, I believe, 1930s that looked at whether a wrongful death statute that used the term person covered a municipality. And they didn't have the same definition we're looking at here. They were using the general definition in Title I, which is just says a person can include a body corporate. That's what it says. It's still there. It's the same statute that still exists today. And the court basically, and again, this is an old decision. It's still binding precedent, but it's old. The new law court might look at it differently now. they said in that context of their wrongful death statute that essentially there's I think they applied something of a presumption again, although it's probably a milder presumption against the idea that a municipality would be covered in that definition. And it's the same sort of premise that, you know, you would expect if the legislature wanted to kind of pull in these sort of fairly unique entities into a statutory definition of person, they would say so more directly than just sort of, in this case, it was a body corporate, a body corporate. So, so I think you could look at that decision. And I think that also sort of pushes against the idea that a municipality is a person under the statute, but less strongly than it would be if this were a state agency. I would be telling you, you should probably not interpret the statute this way. I think in this case there is, and I think this is shown by how the commission split in the past. There is some ambiguity in the statute, and I think ultimately if this were going to go to a court, the court would probably defer to what the commission thought was the correct definition of the statute. There is some legislative history of the definition of how this was applied in the past, where municipal entities were taken out of the statute, is my understanding. And I haven't myself gone through and looked at that in great detail, but it's recounted in tab E, I think, of the packet. So that's also, I think, illustrative here. So if you want my opinion on it, it seems to me when you put all this together that the better view, in my opinion, is probably that a municipality is not a person under our statutes. But I don't I say that with my view is ultimately I think this could be read either way, a court could read either way. That's my personal opinion is that better reading is probably that a municipality is excluded.
But in fact, the commissioner found that the city of South Portland
Correct.
was required to.
That's right. Yeah, absolutely. Yeah. So this debate happened in 2009, and I think the staff took the position, same position I was suggesting. Commissioner rejected it. So there is precedent and that's a very fair point. There's precedent within the agency that that's not the correct way to read the statute. So I think that's also something we should consider.
Great, thank you. Mr. White, please.
Sure, one last point. So when a complaint is filed, the standard in the statute is that the commission shall conduct an investigation if the complainants have shown sufficient grounds for believing that a violation may have occurred. So the commission has various options today. It could decide that complainants have shown sufficient grounds, and you could direct the staff to do an investigation or whatever kind of analysis you'd like. We're happy to do that. You could decide that there are not grounds for investigation. You could allow the people who filed the complaint to provide you some additional written information, and this could be put off for a future meeting as well, and you could receive more information on the legal issues as well. But those are all options, and there are probably other options too.
Terrific. Thank you. Any questions from commissioners for Mr. Bo? Oh, Mr. Bo.
Just one that I realize I didn't tell you what the name of the case was. So just in case anybody wants it, the 1930s case, it's Chase versus inhabitants of town of Litchfield. So
Terrific. Thank you. Are there any questions from commissioners for Mr. Wayne or Mr. Bolton? Yes, Commissioner Marble.
Can you hear me?
Yes.
Thanks. This is for Mr. Bolton. Just again, offering your view or opinion. Absent a subsequent clear declaration and change in law or rules, how should the current commission view a commission's decision or interpretation from 2009 or any previous year? What effect does that have going forward?
So I think as a sort of pure legal matter, you are the commission now. And if you think that the commission got it wrong in 2009, it's within your discretion to change that view of the commission. I mean, I think there is the same considerations here that a court has, and the reason why courts don't often reverse themselves, when they make decisions and then a subsequent case comes up that has the same legal issue, they generally will follow precedent. there's value to that, and the main value, right, is it, it gives everyone certainty about what the law is and what's gonna be expected of people. So if you're, you know, if you're changing things, then it creates uncertainty and nobody knows if they need to follow. You know, in the future, there may be less certainty about whether, you know, municipalities need to be reporting as ballot question committees if they're making expenditures influence an election.
Thank you.
Any other questions from commissioners for Mr. Wayne or Mr. Bolton? Yes, Commissioner Hastings.
Yeah, this question seems to be a threshold question that needs to be answered before we do much else. What were can I have a little more information about the decision made by the commission that a municipality was a person? What was the context? When did that occur again? I'm not sure I have it all down.
Do you have that information, Mr. Wayne?
Yeah, that was in November of 2009. And what had happened was there were a couple of statewide initiatives on the ballot that would reduce revenue to municipalities. And the city of South Portland was sending out their regular property tax bills to property owners. And so they included a flyer in that mailing that expressed what the town council's view was on the referenda. And there was other information about maybe potentially about what would be the impact on the town of these two revenue limiting initiatives. And so the people who were for the statewide initiatives, who wanted to see basically lower taxes, filed a complaint with the commission and said, the city of South Portland's expenses for this flyer that went into the property tax mailing, those should be viewed as expenditures to defeat the two statewide initiatives. And the city of South Portland should therefore be considered a ballot question committee. And the city itself should have registered and filed campaign finance reports with the commission. That was what the complainant said. And the city of South Portland responded and said, we were trying to educate, we weren't trying to influence, and the cost of these flyers wasn't very much also. And the commission received argumentation from the people who filed the complaint who said, one of the categories in the definition of what is a person in campaign finance law is a corporation. And they argued to the commission, a corporation could be a for-profit corporation or a nonprofit corporation or a municipal corporation. So during deliberations, two of the four commissioners who were serving at that time, they took the view that a corporation could be a person. A third commissioner thought that a municipality could be an organization, which was also part of the definition of person. So those three commissioners voted in favor of the proposition that a municipality could be a person in campaign finance law. The fourth commissioner didn't take that view. He disagreed. He said a municipality cannot be a person. But when the commission looked at the costs of the flyer, they found that the city had spent less than $5,000. So it became moot, and they didn't find the city in violation, but they made this finding that a municipality could be, by a vote of 3-1, a municipality could be a person.
But that's interesting because they didn't need to.
They didn't need to.
So, I mean, legally that puts it on a different footing, I would think. I think if they needed to reset conclusion and then they found that the city had to register, I think it would be a stronger suggestion to future commissions that was the policy of the commission. I think the fact that even because they voted it wasn't necessary for their eventual decision, which was, I assume, not to investigate further and not to impose any registration requirement. Am I off base, Mr. Bolt?
No, well, I think that's right. I think certainly that'd be the case if it's a court decision.
Right.
You give it less weight.
Right.
I think, here there, you still have the fact that those commissioners basically publicly told the regulated community, this is our view.
Right.
So
right.
you still have that guidance that went out to the public.
Right.
And so you still have to think about whether you want to change that guidance. But I think you're right. I think that's how it would work if this were a court decision, for sure.
Any other questions, comments, ruminations from commissioners? Yes, Commissioner Marble.
You noticed I raised my hand when you said ruminate.
I did.
Just an observation, and I don't say this to contest or change the legal status of a town or city, but just in the case of South Portland in 2009, and we all see this, it was a matter of the city or town weighing in on an initiative developed elsewhere, i.e. a statewide referendum. Whereas the matter that may be before us today, or is before us today, we're talking about a municipality through its school board and its own initiative. And I don't know if that should change a law or a perception of law or definition, but it's a pertinent fact to me to consider when I look at the rules.
Thank you. Any other questions? Yes, Commissioner Hastings.
I want to agree with Commissioner Marble. I do see the distinction. We're talking about a school board sending out information regarding a project of its own creation, as opposed to advocating for or against a third party referendum. I mean, I don't know quite how you distinguish the two, but I see the distinction. I mean, it was pointed out that this committee had an obligation to educate the public regarding this proposal generated by the school board. So the school board had an obligation to do something to educate. And so the line between education and advocacy gets pretty vague to me. I don't know how you distinguish the two under the statute, but I agree with Commissioner Marble. There is a distinction here.
And I think you put your finger on my thoughts as well. Any other questions for Mr. Bolton or Mr. Wynn before we hear from the complainants? Okay, terrific. Thank you very much. You're welcome to come up to the witness table and address us. Please introduce yourselves first.
Good morning, Chairman Schneider and commissioners here and on Zoom. My name is Mary Ann Lynch. I am a resident, taxpayer, and voter in the town of Cape Elizabeth, as is my colleague Larry Benoit. I will speak first on a couple of general matters and address the legal issue, and then Larry will speak more specifically on the advertising matters and then matters raised by Chris Record.
Thank you.
First, I just want to say clearly and for the record, we're not here motivated, as some have suggested, by trying to silence the school. We recognize that the school has an obligation to educate the voters. But as someone has just pointed out, there is a very fine line between education and advocacy. What we are here today before this commission is to seek the same level of transparency, accountability, and disclosure on government political advertising that is placed on the ads of private citizens who are involved in the same election. And so that is why we're here, and that is our motivation. with respect to the continuance, if I can go to that procedural issue first. As was noted, we received, staff's, lengthy comments and Chris Records' comments only Thursday night of a long holiday weekend. We would like the opportunity to supplement them. We think that they raise a number of questions of fact and law. We have material that we would like to submit regarding the statements of Chris' record. We have material we would like to submit regarding the cost of the ads, especially with respect to whether they reach the $5,000 limit, the jurisdictional threshold. We'd like to make sure that the commission has the material that is tagged. Almost every ad has a QR code. And the QR code sends you to a website with additional information, which we view that must be taken as a whole with the advertising. And we'd like to submit that material.
Well, I'll tell you that, I don't know about the other commissioners, but I followed the link to the QR code, so I know what's on that.
Yeah. We would, but we don't have it officially in the record. I am glad that you
It is now.
did that. Some people don't. I mean, if my husband had a QR code, he wouldn't know what to do with it, but I think for especially voters who are under a certain age, it's all about the QR code. And then we would like a continuance, and this is very important because this is a continuing election. We have one more ad that I cited in my comments to you that came out just last Wednesday. And I expect that there will be more advertising in the next 2 weeks. So we would like a continuance also for the purpose of supplementing the information that you have with any future ads that come out. And I think that that goes especially to the issue of the $5,000 jurisdictional limit. So those are the reasons, those are the 4 factual reasons. Larry will speak to some of these.
Okay, so let's deal with the continuance question right now. And my understanding is that although you're being good natured about it, you object to the continuance. Is that correct? Yes, thank you. So do members of the commission have any questions about the continuance to the complainants? Okay, I made the decision yesterday to preliminarily deny the continuance, but I'd like to have a vote now. I move that we deny the continuance. I think we have enough materials to make the decision right here today. And is there a second?
Second.
Is there further discussion?
I'd just like to hear what the basis of the objection is.
Sure.
I was asked yesterday about the continuance and in terms of our schedules and my schedule in terms of getting here today, we made sure we cleared our schedules, and there's a lot going on in the school district in May. So we were ready to continue today, and then the possible June date on the way. So I think that was a potential concern for Mr. Wing, that I was unavailable at that time.
Thank you.
Is there any objection to supplementing or difficulty with supplementing the record?
I think we have a lot of supplementary.
Are you saying that everything's on the record now, or are you saying?
No, I'm saying that not everything is on the record right now. The staff has, I thought based on the information received from the school, which was rather general in its billing nature, the staff has done a good job of taking what I would call a swag at the estimates. We would like to have a FOA to further identify the costs. We place similar ads, and we have a very difficult time believing that the production of those ads is only $300 a piece, number one. Number two, the ad that ran just last Wednesday had a QR code to the date of the election and an exhortation that the vote was crucial. These were points that the staff said they didn't see in some of the other ads. We think that additional ads before the election, which we haven't seen and you haven't seen, should be part of the commission's full package of information before you determine whether the jurisdictional amount has been raised. And then also, and I was just about to get to this point, your counsel spoke to the legal issue. And I would like to speak to the legal issue as well, but also to the extent, we would like to have an opportunity, let me back up a minute. We were really truly surprised that the staff walked back the 2009 precedent. We frankly thought that that was something that we could rely on. And that the commission had spoken with some certainty about that. So-
Well, it's up to the commission to make that decision.
No, I understand that, but it did. We're both lawyers and we understand that people take some value in precedent, and as your own counsel said, there's some discussion about predictability. So we were surprised about that, and we would like an opportunity to brief that issue. So that would be one more thing that I would like to include in an extension of time.
Thank you. Do you have further?
Well, it seems like a fairly complex issue, one that wasn't fully apparently resolved in 2009. There's some differences between this case and as Commissioner Marble pointed out. And so I guess I'm just going to ask the question as bluntly as possible. What is the rush? If this is an important issue and the facts are important, do we want to be saying 3 years from now saying, oh, that was different, without having fully fleshed out the nuances of this particular case?
I don't feel any rush, particularly from my own perspective. I just feel that we have enough information before us, and the complainants can kind of add as they're discussing things today. And they've added even more information last night, this morning. So I think we have enough, but that's just my take on it. Yes, Commissioner Hastings.
Yes, one argument for the continuance that I do not agree with is that we would hold this open while they look for future expenditures that might get them over the limit. I don't think that is, once the complaint is made, I think we would deal with the facts that exist at that time. And I don't think we should take the position that we're not sure if there's enough, but if you think they might spend more in the future, let's just hold this matter open until you think you can dredge up enough expenses to do it. I think we have to deal with the facts that exist as of the time of the complaint and with respect to expenditures. And I would not agree to a continuance at all based on those grounds. In fact, I don't think we should consider future expenditures. That would be a different complaint.
I agree with you. Thank you.
I agree with that as well. I'm simply confused mostly about the evidence regarding the QR codes. Is that or is that not in the record? Do we have physical copies of
The
what?
QR codes are on the ads.
I understand that,
I use my phone to pursue the,
but do we have any hard copies in the record?
I don't think we do. Do we?
I don't believe so.
If I might,
But you've addressed it in your email.
I have, but what I've addressed it in my email. What you don't have is copies of that site that you went to see.
Right.
So
But
you do lack that.
But you had told
But
us about it.
I have told you about it, yes. If you want to accept what I
Your
wrote,
word, yep.
then it's in the record if that's how you want to accept it.
You're a person of good faith. I take your word.
And again, I would feel more comfortable if it was in the record in a hard copy.
Sure.
A website that's gonna evaporate, after this is over.
Mr. Wayne, could you make a copy of the where that QR code takes us?
Absolutely. Well, I mean, I believe I received a screenshot of that in my email.
Yes, that's right,
And
yes.
we could make photocopies right now and
Okay,
make
so
them
let's-
available.
So we do
Let's take a
Yeah.
10-minute,
Okay,
take a 10-minute break. We're gonna take a 10-minute break. Commissioners Marble and Hastings, did you get the email with this material?
I had not checked my email.
All right. Commissioner Hastings or Commissioner Marble, you should have an email with this additional material.
Oh, okay, got it.
And Commissioner Marble, you're still muted.
Yes, I do.
And you are now unmuted.
Yes.
Okay, so we have on the floor a motion to deny the continuance. It's been seconded. Is there further discussion about that?
Just one more question.
Of course.
The intricacies of the legal issues here today. Is it a possibility that we could take this under advisement to after the presentation of evidence to look at some of the legal issues, such as the case that Ms. Bolton has?
I think we could absolutely do
Okay, all right.
No.
that. Commissioner Hastings.
You know, the more I think about this is a difficult question. Whether or not a municipality in any circumstance should be, or the state, I guess, the municipality is what we're concerned about, or it's some parts like a school board are subject to this statute. And as Commissioner Marble pointed out, there are some nuances here. We have a precedent, but as Commissioner Marble pointed out, dealing with a external referendum as opposed to a question proposed by the municipality itself. In which case you would certainly expect that the municipality is, to me, supportive of it. And I would prefer to have a little more advice, perhaps from Mr. Bolton, as to whether or not that distinction is important or makes a difference, or I'd like to consider that a little bit more. I think before we overrule or support a prior ruling of the commission, I'd like a little more information.
Do you think it's possible that Mr. Bolton could address that now, or do you?
Well, I don't know. Mr. Bolton does miracles, so I don't, but I'm not going to put him to that obligation.
He's pretty impressive, I gotta say.
Can I just
Of course.
comment on that? I mean, having more access or more facts before the commission that Mr. Bolton could also address. I mean, I'm not opposed to taking testimony today. And you know, having the benefit of more time to review the legal nuances. And I think having more testimony today would help in that effort. Differentiating, if appropriate, the Portland case from this.
Commissioner, or actually, Mr. Bolton.
So I could offer some thoughts. I also, if you wanted sort of a more fulsome consideration of all this, I'd be happy to put together a memo for a future, for a future meeting that really goes through all the stuff in more detail than I'd be able to do kind of on the spot here.
Let me touch base with Commissioner Hastings. Commissioner Hastings, would you be happier with a memo that addresses it in detail, or Mr. Bolton's kind of off the cuff thoughts?
Oh, I think I know this is, I think it's an important distinction. I think I would appreciate a memo, you know. I also believe just that we should, our continuance should be based on that, and that we should make it clear that we're not opening this up for, searching for expenses made in the future. I think we have to deal with this complaint based on the facts that exist now as the time of the complaint. Or else I don't want to just set a precedent that somebody can file a complaint, and if they don't have enough numbers that, well, if we put it off a month, maybe they'll spend some more and we can then reach the threshold.
A good way to do that might be Commissioner LeClaire's suggestion. Maybe we take testimony today and then defer our decision until after Mr. Bolton can help us analyze the law a little bit better. How about if I modify my motion to move that we take testimony today, and that will close the evidence, and that we then are free to defer the decision until after we've had a chance to analyze the law a bit further. Is there a second to that?
I'll second that.
Okay. Is there any discussion of that motion? Okay, I'll take a roll call. Commissioner Hastings,
Yes.
Commissioner Marvel,
Yes.
Commissioner LeClaire.
Yes.
I'll vote yes as well. So that's what we're gonna do. We'll take testimony today. That will close the evidence, and then we'll allow Mr. Bolton to address some of the legal issues a little bit in the meantime, and we'll defer our decision until another day. So please go ahead with your.
Thank you. And if I may, I would like to address the legal issues. The staff had expressed discomfort, to use their word, with regulating public entities as ballot question committees. And they said, absent clearer direction from the legislature. Notably, staff's discomfort is in direct contradiction to the only legal precedent of this commission, which we felt was directly on point on the matter.
Let me stop you just for a second. I think you're reading the materials that you submitted to us. You don't have to do that. We've read and analyzed those thoroughly.
Oh, okay, then I would just say then that we would also like an opportunity to brief this issue more fully, to the extent that you will be receiving written legal advice from your staff. We hope we would have the opportunity to also brief this as well. Obviously, with whatever schedule you deem important.
What do commissioners think? Commissioner Hastings.
Guess I don't mind either party submitting on that point alone, any written opinion that they have, essentially a brief.
I think my position would be that we would welcome briefs on legal issues, but that the evidence will be
Right.
finished. So I think that's a realistic and wise position, Commissioner Hastings.
Thank you. I'll turn it over to Larry at this point.
Can I ask one question?
Of course.
A lot of stuff here. Does the record with the additions that have come in over the last couple of days include anything about future expenditures? that you addressed today?
We did send in an ad that was published last Wednesday.
And that was
And that is,
post filing of the complaint. So we need to address whether there's a cutoff and what that cutoff is, and include or exclude things that are past that date.
Sure. Sure. I think, but let me discuss it with the commissioners now. I think my thought would be that, today is the cutoff. Anything that's submitted in the record or presented in testimony today would be considered as evidence.
Including speculation about future.
I don't think speculation is admissible evidence.
Okay.
Do the other commissioners agree with that?
Yes.
Yes.
Okay, great. Sorry for all the
no,
machinations.
this is all important, and we respect the importance of this.
Mr. Benoit.
Thank you, Mr. Chairman, and members of the commission. My name's Larry Benoit. I'm one of the complainants, along with Mary Ann Lynch, regarding the expenditure of the funds. These are public funds, taxpayer funds, by the Cape Elizabeth School Department for the purposes of influencing an election, two of them, actually. I did want to just make one comment as a layperson, that in filing this complaint, I believe that I could in part trust the precedent established by the commission with respect to prior cases that would be relevant to this complaint. I don't know the legal nuances, but as a citizen, that was my thought, that I could trust that and I could rely upon it partly as a basis for the complaint. As we undertook this complaint, we were looking for transparency, accountability, and compliance. We're not looking for punitive action against the school department or the superintendent. That's not our purpose. What really distinguishes this issue is that it entails the expenditure of public funds. It's very distinct in that respect from almost all, if not almost all, maybe all of the cases that this commission has dealt with for many years. It's a very unusual case for that reason. And it's my view that public officials, whether they be school board members, town council members, members of this commission, the legislature, have a special fiduciary obligation to see that these funds are properly expended. And if they are, that there be transparency in how they're expended and how these funds are utilized. And we've not seen that. That is, I believe, the core understanding in the law to in fact have campaign finance committees register and disclose receipts and expenditures, transparency and accountability. And that's the most troubling aspect of this. Now, we would be completely satisfied, and Dr. Record indicated in his interview, based on what was reported by the staff, that he'd be happy to report these if the commission found that it should. And I think that is truly the answer, because it provides for the transparency and accountability that we so dearly want to see here. Now, I served on the SBAC committee. I was a member of that committee appointed by the joint committee of the school board and the town council. I was one of 5 public members. The work of the committee.
Mr. Benoit,
Yes.
could you tell us what the SBAC committee is?
Yes, School Building Advisory Committee.
Thank you.
Sorry to use that acronym.
No, that's okay.
Right. And there were 9 members on that committee. There were 5 public members. I was one of them. And the work of that committee was to hire an architect and an owner's representative to look at the needs of our 3 schools in Cape Elizabeth and to consider options as to how to address those needs. Harriman was hired as an architect, and we had the firm of Townsend and Heary as an OPM. Harriman made a set of recommendations for our consideration, 7 options. We looked at those, we reduced those to 3, and we finally reduced it to a 1 recommendation that was made by the committee to the school board. During that period of time, I also served on the Finance and the Communications Committee. And we discussed the expenditure of funds, and we were authorized to spend funds for public notices. And the idea being that we needed to do a better job of communicating the needs of the schools to the public, and have the public play a far greater role in the evolution and development of our options, and which we did. And I agreed with that. And in fact, I've submitted here today just an example of some of the ads that were run to identify these options. This was information. And it's an enormous distinction between these ads that were run while our work was underway, and we finally reached a recommendation that was made to the school board, and the ads that followed that were intended and designed to influence the referenda question for the final recommendation that was made to the town council by the school board. The problem with all of this is that the school board rejected the recommendation of the School Building Advisory Committee. We made that decision on May 9th. Our committee was immediately suspended by an action of the school board chairperson, along with the cooperation of the town council chair. And we had no further substantive work done by the committee, and we had a final meeting on June 24th where we were terminated officially. At that point, going forward, the school board rejected all of the recommendations and then proceeded to develop its own plan to build a new middle school and provide some funding for our high school and our elementary school. We played no role in any of that afterwards, and we never authorized the expenditure, our committee, for influencing the election or running ads in support of the bond issue. All the ads that followed after that had nothing to do with the work of the School Building Advisory Committee, and in fact had nothing to do with the charge that was given by the council and the school board to create that committee, because that charge died when the council and the school board terminated the committee. The remaining funds were then turned over to the school department, and then they began to utilize those funds to develop their own plan and to run advertisements ultimately after the council approved the plan to put it on the ballot for the November 5th referenda vote, municipal referenda vote. That's the history of the committee. Now, I want to point out that Dr. Record, during the time that we concluded our work and the funds were in question, the town manager, Michael McGovern, suspended expenditures until such time as he reviewed the status of these funds. Sometime in August, he wrote Dr. Record in an email, which you have a copy of, and said, you can go ahead and proceed to use these funds for advertisements, but he recommended that Dr. Record contact this commission to understand how state law would apply to those advertisements. That was at the time when Mr. McGovern was serving as town manager. More recently, after leaving that public service, Mr. McGovern wrote a letter to the town council, and you have a copy of that. And he advised the town council that the school board should register as a ballot question committee, and that the school board should file the requisite campaign reports for finances, receipts, and expenditures. And in addition to that, you'll see in the letter, he said that if the school board doesn't, the town should file, because he said this is all about transparency concerning the expenditure of public funds. And I go back to this question here. This is what is a huge distinction here. You have a government and you have citizens. We're a citizens group. Our group actually supports a huge investment in our schools, $64 million. We just disagree with this particular proposal. We don't think it's right for the town. We've had to go out and raise money, file as a ballot question committee, and here we're confronted with a school department that's spending our tax dollars to advocate for this bond issue, which was defeated last fall. And here again, it's the same, this really basically the same project. a new middle school with less money for our high school and for our elementary school. And we're up against this as citizens against government. And in this case, it's an imbalance. And what we hope that this commission will do is understand that balance and that trust about the use of public funds, of taxpayer dollars, to advocate for a bond issue that's going to raise taxes dramatically. We're talking about a bond issue of $86.5 million. This is not a small matter. This is not something that is going to have little impact. It's going to have a huge impact in our community, both for the quality of schools and education. And so these are my points that I think you really need to consider, especially this distinction involving public funds. Now, I submitted a memo here. You all have this. I went through the report that was done by the staff, and I added up all of the ads that they identified in the table that has italicized text. And those were the ads that they said had the indicia of supporting and influencing an election. And there were 4 ads there. Those ads were $1,015 each. And they estimated that the cost of preparing those ads was $300 a piece. The total for that is $5,260. But that, for some reason, I can't explain it, wasn't actually summed in the memo that the staff provided to the commission.
And
So-
if I might just interject, and that does not include the 521 ad, which would be another $1,300.
Right, and I want to emphasize, these are the ads that the commission staff identified as having the indicia as influence in election campaign. That's the minimum. We believe there were several other ads that did likewise. In fact, we believe that after the town council in August of last year signed a warrant to put the bond issue on the ballot, every ad after that is on the face of it, an ad in support of the bond issue, again, using public funds. Now, I understand the commission doesn't have the authority to make a determination on the use of these public funds for political advertising. It's not in your jurisdiction. But we believe that the school department does not have the authority to spend funds for that purpose. And we cited a case involving the Turnpike Authority that Justice Alexander ruled on. And he said in that ruling that it was his opinion that no public agency could expend public funds to influence elections without explicit legislative authority over the governing body. And then in our case, that's the town charter in the town of Cape Elizabeth, and there's no such authority in it.
And I just want to let you know that that's outside the.
That's right,
purview of the
we
commission.
understand that.
We understand that, but see, our concern about this is the use of public funds. And I would just wanted to point that out, that there was a mention in the staff memo that you didn't have that authority. We acknowledge that in our complaint. I just want to be clear. that
I just wanted to make sure that
Yeah,
today here.
I understand,
we don't realize
yes, I understand. So we have here evidence that the staff has recognized are indicias, as they call it, demonstrating that a objective reader would conclude those ads were intended to influence the election and support the bond. And influence election support is the key word. It's in the definition in the statute. Now, in my career, 30 years, I was the chief field representative for Senator George Mitchell. I was the chief of staff to Congressman John Baldacci. And during that time, I took time off to manage their re-election campaigns, 2 for Senator Mitchell and 3 for Congressman John Baldacci. After retiring from that career, I went to work for a law firm, and there, in a government relations practice, I was the lead manager for 5 statewide ballot questions in opposing the citizens' initiatives for the taxpayer bill of rights 2 times, the Plesky tax cap, another one involving aid to education, another one involving a tax reform bill that was repealed. I have acquired in that experience a lifetime of experience working with consultants in all sorts of campaign capacities. That would be television, radio, print communications, social media and so forth. And I can tell you from my personal experience, $300 is a paltry amount to pay to have a full-page color ad with the complexity, with the graphics, with the messaging, and all of the other work that went into production of these ads that was provided by Harriman. I believe that the estimate woefully underestimates the true cost of it. And as you can see by the broader invoices that was received by the school department, we're talking tens of thousands of dollars in expenses here that were used in so-called community, which is kind of a broad catch-all. One of the reasons we asked for this continuance was to see if we can find more detailed, granular information regarding those billings, because it's so broad that, you know, you leave the staff and everybody else to guess. But I can tell you this, when you develop ads, it requires an interaction between the consultants and the client in a great detail about messaging, about design, color, all kinds of issues. Typically hours, not 1, not 2, no, not 3 hours. I can tell you that from my personal experience, and I believe I'm expert in this area given my career. So these are just among the many issues that I think here that this commission really needs to consider. That we are talking again here about taxpayer dollars, thousands of dollars. We already have information that the staff believes that over $5,260 was expended for the purposes of influencing these 2 bond issue questions that are on our municipal ballot. Anyway, I would be glad to answer any questions regarding this. Again, the SBAC never envisioned spending funds after the final project was put on the ballot by the town warrant. And we didn't exist at the time. We were terminated. Again, our last meeting was on May 9th when we made the recommendation. It was rejected quickly by the school board. We were suspended. We did no further substantive work. We had a final meeting to say farewell to us and thank us for our work on the 24th of June. During that time, the school board took over all of the project. We were officially terminated. The funds were put into a suspended stasis by the town manager. He later reinstated it, urged Dr. Record to contact the commission. And to the best of my knowledge, apparently that didn't happen because Dr. Record claims in the interview that he didn't know whether this applied or it didn't apply. So those are the key points that I think the commission could please consider in its deliberations.
Thank you very much.
Thank you.
And just as a threshold matter, I know you dispute this, but I want to point out that the cost summary that you gave is over the course of 2 elections.
Yes.
Okay, thank you.
Yeah.
Are there other comments or questions from commissioners for the complainants?
Right. Chairman Snyder, could I just make a comment on that? Those are the 4 ads that the staff.
Yes, I understand.
Right, okay, just wanted to be sure.
Yep.
We believe that the ads after the town council put
No, I
it on the
understand.
ballot, right?
I do understand. Thank you.
Yes.
Are there other questions or comments from commissioners?
I have a couple of questions, just,
Sure.
just simple factual questions. The school board is an elected entity, is that correct?
Yes.
And the town council is an elected entity.
Yes.
What was the name of your commission that you served on?
The SBAC.
That's the School Building Advisory Committee.
Was appointed by the council or by the school?
It was a joint committee was formed to go out and select and recommend appointments of the public members.
Was appointed by both bodies.
By
though.
both bodies,
Yeah,
both bodies
yeah,
appointed,
okay.
yes.
And the expenditures that are at issue here today were voted on by the school board or by the town council?
Town council.
They were voted on for each of these ads was voted on?
No, the total amount of money that was allocated to the School Building Advisory Committee was provided for in the form of an appropriation or an authority of approximately just under $1 million.
And was that authority specific to any public relations or public information budget within that?
Yes, some of it was authorized to be used for public notices. And again, as I pointed out, you've got an ad here. We had 7 options at first. We had 3. We had a number of advertisements inviting people to public hearings. We had advertisements describing the details and the tax impacts of those options. And I supported that. And I specifically said at a meeting that we should not spend public funds to support the final solution that would go on to the ballot. I specifically urged the committee not to do that. We had no further discussion about it. And again, the committee was terminated before it would ever have been involved in that decision.
Are you aware of any discussions at the city council or the school board about these particular expenditures or expenditures to advertise?
I don't know about formal discussions. No, I've talked to some counselors who objected to these ads.
Okay. Thank you.
Thank you. Any other questions or comments from commissioners? Okay, seeing none. Thank you very much.
Thank you.
We really appreciate the information you brought. The respondents, you're next. If you want to bring up another chair, you're welcome to. And please introduce yourselves and
Yes, good morning, Executive Director Wayne and distinguished members of the commission. I'm Dr. Christopher Record, very proud superintendent of Cape Elizabeth.
I'm Cynthia Volz. I'm Vice Chair of the Cape Elizabeth School Board. I'm also former chair of the school building, from co-chair of the School Building Advisory Committee, and I'm a member of our Community Outreach Committee of the school.
great.
I'm Marcia Weeks and I'm the school finance director.
As we respond, primarily, I humbly request that you as a commission refer back to the letter I submitted on May 19th to the commission and to the executive director. Also refer you back to Director Wayne's 19-page memo to the commission. However, I do have a few highlights to share for your consideration as you deliberate this matter. First, I want to highlight the public communication role of a superintendent under state law and school board policy. It is my public duty on behalf of the board to communicate with the public and keep the public well informed. I refer to page 10 of Mr. Wayne's memo as he highlights policy KDA. That is a public information program policy passed by the Cape Elizabeth School Board. There is no question that a school building project is a serious matter of significant public importance. The public needs to be well informed of the need, the potential architectural solution, and of course, the tax and fiscal implications. We have made a substantial effort to engage the public in this process, seek their input, and keep them up to speed along the way. Secondly, I want to speak more directly regarding the various building project referendums. Historically, the Cape Elizabeth School Board and Superintendent have made substantial public outreach efforts during the 1993 and 2004 school project referendums, including a multi-page insert in the Cape Courier. In July 2021, I became superintendent in Cape, and besides returning from COVID, the #1 directive from the school board was to help move a critically needed building project to referendum. Unfortunately, the November 2022 referendum lost by a wide margin. This loss led to the co-creation of the School Building Advisory Committee, or SBAC, by the school board and town council. As Mr. Benoit mentioned, there were 9 voting members, 2 school board members, 2 town councilors, and 5 citizens. Mr. Benoit was one of those citizens. A lesson from the 2022 referendum was there was not enough communication with the public. Therefore, part of the charge of SBAC, the School Building Advisory Committee, that's page 9 on Mr. Wayne's memo, was a public outreach component through multiple channels to inform, engage, interact with the public, the citizens of Cape Elizabeth. A public outreach subcommittee was formed to lead this effort. Mr. Benoit, as he stated, regularly attended these meetings, over 20 of them, I recall. Through a survey that was sent out to every household by SBAC, we learned that the Cape Courier, the local newspaper, was a very important way to communicate with our citizens, particularly those without any children in our schools. SBAC, as Mr. Benoit articulated, was eventually sunsetted by town council and in the school board by the end of June 2024. The school district moved forward with a project from that point and took over public outreach efforts leading to the November 2024 referendum. We utilized the Cape Courier informative ads that continue to educate the public and engage the public on the deficiencies of the schools and how we hope to address those deficiencies. The public needs to know this information. Unfortunately, this referendum lost by 166 votes. The school board moved forward with a modified project that is headed to the voters on June 10th, in just a couple weeks. Public outreach efforts continued this spring. In fact, the board, realizing even more important how important public outreach is, has created a public outreach subcommittee to enhance its efforts. This goes beyond the building project. This is on any topic that's happening in our school district. I think it's really important to communicate with the public. In conclusion, one, it is the fundamental duty of a superintendent on behalf of the school board to inform and interact with the public, and the duty of the school board to provide safe and educationally effective facilities. Two, it never crossed my mind the question of registering as ballot committee. It is clear in the ads that the school district was paying for them. We share our financials monthly at school board meetings to the public and the school board. Three, I'm not aware of any school district ever registering as a ballot committee. Four, Harriman Architecture Firm is the preeminent architecture firm in the state for building main schools. They never brought this topic up, which tells me other districts are not doing this. Finally, it has been our intention through the very referendums to engage, inform, and educate Cape citizens on a matter of significant importance to the community. However, if the commission determines we should have registered, we will do so as quickly as we can. Thank you, and I'm happy to answer any questions, as is Cindy and Marcy.
Thank you. Do you want to offer testimony or just be ready to answer questions?
Available.
Awesome, great. Are there questions from commissioners? Please.
So, one of the important purposes for the disclosure requirements that we have is making sure the public knows about expenditures. So, for argument's sake, what you mentioned, that you share financials on a regular basis with the public. When you say we, who are you talking about? The school board, the city council? What do those financials contain? Do they contain specific details about the money that was expended for this informational campaign? And was it readily accessible to the public?
I'll turn to Finance Director Marcy Weeks to help answer that.
Yes, our process is that every week our warrants are reviewed by our school board and signed, also reviewed by our town manager. Then they're posted every month in a report, a full financial report that I provide at our school board meeting, which is posted online. And in addition to that, we are also posting our audited financials yearly. Our auditors go through our expenditures additionally, and that's also included with the posting publicly.
And we have had, sorry,
No, go ahead, please.
we have had citizens put in FOIA requests for information, and we readily provide it. All of our financials are public information.
So the information regarding the money that was spent on these newspaper ads, was that specifically identified in your monthly report and published online?
I was specifically identified only by the account code for advertising dues and fees and professional services in the superintendent's budget. And then on the town side, it's the same thing for the capital project when the funds were contained in one fund. It's the same thing. It's contained by account code. And it's broken down by vendor. And if anybody ever has requests to us as well, we provide that to any citizen.
One other
To me,
question.
I just wanna make sure we're as clear as possible.
Yeah.
And maybe I misheard them. In the monthly financials we share with the school board and the public, it does not, it's not explicit on the vendor. It says
By the account
by
code,
the account code and what the topic is.
correct,
So it's probably under an advertising.
Yeah,
correct.
yeah.
Are you aware of any meeting, town council or school board where the specific decision to expend money on these ads was discussed publicly?
We have been discussing them, most recently at the Public Outreach Subcommittee, which has a couple board members and myself that meet. We've been meeting either on a weekly or bi-weekly basis to discuss a number of topics, but often one of the topics is what are we gonna put in the next informative ad to update the public? I regularly, at school board meetings, will update the board on the building project, as will Cindy when she was co-chair of SBAC. So we'll talk about public outreach at those meetings. But the board, other than voting on the regular yearly budget, has not ever endorsed saying we're gonna expend X number of dollars on this ad. That's a determination made through the superintendent's office and the business office as part of our directive to lead communications.
I will comment, though, the board did authorize the superintendent to continue to work with Harriman to rerun the project after the November referendum. And the assumption by the board is that the Harriman work includes supporting our public outreach efforts to educate about the project.
Thank you. And one other question.
Of course.
You had mentioned that Harriman is a significant company that has engaged with multiple school districts and towns across the state of Maine. Is that correct?
Correct.
And educating the public on the impacts and benefits.
That's a key part of any public school project.
So is it likely or unlikely they would have done similar information sheets for other school districts?
I live in town next door, Elizabeth, and their Harriman works, I'll just tell you, Scarborough. And Harriman is working with them, and I have seen similar advertisements in the local paper in Scarborough.
So it's not likely these were created whole cloth specifically for Cape Elizabeth, probably a template or something.
When they were hired, they were hired through SBAC, School Building Advisory Committee, and they shared with us some of their public outreach materials, because that's what some of our interest was, and they were templates. And certainly they had details that are specific to each community, but the ads that I see in Scarborough are very similar to the ones we see in Cape Elizabeth.
And the ad materials are also used as flyers, as graphics on the website, within public presentations where they've done public forums. So the content itself is used in many different.
That actually was gonna be a follow-up question. These ads were put in the paper, but could you, beyond that, address what
they
they
have-
specifically have been used for besides advertising?
Yeah, you can go. I can add in.
And we've had public forums to notify the public or inform the public of the project. Those have been handouts at the public forums. They've been part of presentations, or components of the ads have been part of presentations. Shown at public forums as handouts. The flyers, some of the flyers have been placed in community locations such as the library, or handed out at a school tour, for example. So they're used as just an information sheet about the project, whenever we're asked for information on the project.
So they weren't specifically designed only for newspaper advertising.
No. It's sort of an overall communications
Tool.
tool for us.
So, any other questions from commissioners, questions, comments? Okay, hearing none, thank you very much for your presentation. I really appreciate it. So that concludes the evidence. Now it's time for us to discuss the issues here. I will make a motion that we take no further action on the complaint, and I want to say why. I analyzed these ads very closely. I looked at all of them. I followed the QR code to the linked page. I read all of that. And although some of them come perilously close, I cannot find that they consist of advocacy. I think the school board and the superintendent have a duty that's enshrined in law for them to present information about it. Any kind of a big project like this, it's a common sense duty that they have to present information to the community. And I think that those ads, amongst the other efforts that they had, presented valid, non-advocacy type of information to the community. And because that's my take on it, I don't really need to even reach the issue of whether or not a municipality can be a person under our statute or not. So that's kind of where I'm coming from, and what leads me to make the motion that we take no further action on this. Is there a second?
I'll second it, but just to open some discussion.
Great, thank you.
So, Mr. Bolton, can I?
Of course.
Thanks. If a primary purpose is informing the public of as they are obligated to do, and there is an incidental advocacy, does the law address incidental versus primary?
It doesn't
Purpose.
it doesn't address it in a direct way. Let's get the statute in front of me here, answer your question. Yeah, the statute says to be a valid question, your purpose, the purpose must be initiating or influencing a campaign. My take on that, and Mr. Wayne may have thoughts as well, but my take on that is that at the very least, you probably need it to be a main or a key purpose that just sort of that it needs to be sort of front and center in some way. But the language doesn't provide modifiers, it just says for the purpose of.
And that was my interpretation.
Thank you.
Is there Commissioner Hastings?
Just a question, if this motion were to pass, does that bring an end to this hearing, that there's no need to decide whether or not a municipality is subject to the act?
For my purposes, I would not need to know that. So for my purposes, it would end my inquiry. But the motion was to take no further action. So there may be other reasons, other commissioners may have other reasons for taking no further action, or they may oppose the motion and wish to have further information before we vote. I think it's entirely up to the commissioners. Commissioner Hastings.
Well, I think the question of whether or not a municipality should be or is covered by the act, depending on various scenarios, is an important one going down the road. And that I look at some of these ads, especially at the QR code thing. There is a element of advocacy, which you would expect when an organization who's proposing the project, how can it help but advocate for it when it puts all this information out? And which I certainly, doesn't
Commissioner
surprise me a bit, and I find it very, it's just, it's obvious. But the real
Hang on just a
question to me is whether or not should governmental entities such as this be required to register, even to advocate for their own governmental projects? I don't, that's the threshold question to me. And I think it
there,
deserves
let me-
answering.
let me hold things up for just a second. I think there may be some kind of a,
Commissioner Marvel is having some connectivity issues, and I'm going to ask him to exit and rejoin just because he's just hearing intermittent pieces, and you can see the video is just.
It's frozen.
Is frozen.
Yeah. That's great. Please do.
Yeah.
Did you hear that, Commissioner Hastings?
Commissioner Marvel, oh, he couldn't hear me?
He was having trouble hearing what was going on, so I think maybe you may want to recap. He's gonna exit and come back, and you may want to recap what you were discussing.
Oh.
Currently talking with Lori.
There's always technological issues. Although we managed to pull off, this is a fairly complicated meeting. We usually manage to pull it off pretty well. So Lori's listening out in the other room to see if it seems to be working.
I feel pretty special. Thank you.
You are special, man. All right, great. Commissioner Hastings, are you back with us?
I am.
All right, we've got Commissioner Marble on a telephone line. He's having Wi-Fi issues. And I thought maybe you could recap what you were discussing just before the break. And I may stop because I want to make sure that Commissioner Marble is hearing what you're saying.
Oh, you're making me remember, huh?
Okay.
Well, I guess, but procedurally, I thought earlier we voted to allow a continuance for some further briefing, and now this motion, though, however, seems to say that there was no advocacy over $5,000, so that would then moot the legal question.
That's
that
just
where-
in my, that's
Is that
just
where
in
we
my,
are?
that is just in my take on it. The motion is more general. The motion is to take no further action, but you may have a different reason and we can defer our decision if you are interested in further legal analysis.
Well, I will say then that, in my opinion, there is an element of advocacy in these documents that is compelling. I guess I haven't really focused on the threshold amount. I am very interested in further answering the question of municipalities being subject to the act in this type of referendum. And I guess if we support your motion, that's the end of it. Is that correct?
Well, no. We have a couple of options. We can vote right now if you don't need further legal analysis, but if you would prefer further legal analysis, we can defer the vote. That's what we decided earlier.
Okay. I guess I would like the legal analysis, so.
Then by golly, we will defer the vote, but we can discuss it now.
Well, there's a motion on the floor. I don't mind. You've made a
Right.
motion, I believe, and it's been seconded.
I did, and it was, and I think we have an obligation to discuss it in public. So is there further discussion from commissioners?
Can you hear me on
I can hear you. Can you hear Dennis, Commissioner Hastings? Can you hear anybody, Commissioner Hastings? Could you hear Dennis a moment ago?
I could.
Yo, you could, good. Okay, great.
I'll try to keep my comment very brief. I'm supportive of the motion to take no action. And I am certainly not opposed to further legal analysis. I think we can always benefit from that. But I want to say on the record that I have significant problems with the idea of our applying the direction, guidance, and limitations that are imposed on either PACs or ballot question committee on publicly elected organizations like town councils and school boards. The purposes, goals are different in each case. There are avenues in law as well as custom for disclosure of information with town councils and school boards that otherwise would not apply to political activism. And frankly, in the real world, a greater portion of the public knows who's on their council and their school board and what they feel than would know with a BQC or a PAC, except for our procedures where that has to be disclosed. So I think regardless of the ultimate conclusion of whether or not a municipal corporation could be an individual, and I'll confess I get lost in some of those conversations. I don't think the applicability of the function of a BQC or a PAC is appropriate for either a council or a school board. And that's why I will be voting to take no further action.
Thank you, Commissioner Marble. Is there further discussion amongst commissioners? Okay. Seeing none, we voted earlier to defer the vote. We're going to ask Mr. Bolton to brief the issue a little bit more, in a little more fulsome manner. Thank you very much for coming, everybody, for coming and presenting evidence. We really appreciate it. It really helps guide us along in evaluating these issues. So, as you can see, there are some really interesting kind of long-lasting kind of issues that this issue has brought up. So, thank you again for coming. We really appreciate it. And I'll close the evidence and the discussion for the time being. So we'll move on to item 3. Which is a report on campaign finance constitutional amendments that we are required to do. Mr. Wayne.
There was a citizen initiative that directed the commission to write an annual report on constitutional amendments of U.S. Constitution regarding campaign finance, and we published our first report in 2024, and the upcoming report is due by the end of July in 2025. So I had written a cover memo to the commission members stating some preliminary ideas about how I'd go about inviting public comment and what would be included in the report. And I accidentally, walked my packet into my office, so I don't have a cover memo. But it was intended to be a springboard for discussion. Thank you, John. My thought process was staff would check on any constitutional amendments that have been proposed in Congress since our last report. We would invite public comment from anyone staff could identify as an interested person. That would include people who have signed up on our interested persons list generally for events of the commission. We'd also be going back to the same people who commented a year ago. If there are any public interest groups on free speech advocates or pro-regulation groups, we'd invite them to comment as well. Consistent with last year's procedures, my thought process was not to hold a public hearing, although that's an option for the commission. In the last year's report, I felt this was sort of me freelancing. I thought that there was a need to, sort of explain sort of the legal landscape and why these constitutional amendments were being proposed from my point of view. I don't think that's necessary in the next report because there have been significant developments, so I would think we could just rely on last year's discussion along those lines. My thought process was also for me not to summarize the comments, but rather to attach them to the report. But this is all up, I just wanted to see if that was consistent with what the commission wanted. That was my proposal.
Terrific. That would be exactly consistent with what I want. Should we take a vote or?
Can I make a comment?
Please do.
Don't have high energy on this as far as, directing Jonathan exactly what to do. But just in the case that there are new readers to this or it's new information, I think a little bit of summary might be helpful. That's all I'll offer.
I don't know if that's specific enough direction to really make anything happen or not. I mean,
80% of what he said, so.
oh, shoot.
I'm half blind here.
I mean, my,
I just wanted to make sure that it's coherent to whoever may have interest in it, that's all.
yeah, and my thought with this kind of requirement is to do exactly what's been required and not add a lot of fluff.
Yep.
Any other thoughts from commissioners? Okay. Is that?
I don't think you need to vote on this unless you
I don't think
tell him
so
to do
either.
something different than
Yeah.
what he's.
I think your proposal is right on.
Okay, great, thank you.
Great. All right. Is there further business to come before the commission? Seeing and hearing none, I will accept a motion from somebody if they'd like to make it.
I move we adjourn.
Is there a second?
I'll second that.
Terrific. It's been moved and seconded that we adjourn. No debate is possible, so we'll go right to a vote. Commissioner Hastings,
Yes.
Commissioner Marble,
Yes.
Commissioner LeClaire,
Yes.
and I will vote yes as well. Thank you very much, everybody, for coming and bearing with us. There's some